So today we're joined by Advocate Nonku Shombe of the FAIS Ombud, Peter Nkuna, the Senior Assistant Ombudsman from the Ombuds for Short-Term Insurance, and Thokozile Mashlangu, the CEO of the Insurance Institute of South Africa. Nonku Shombe is an admitted advocate of the High Court of South Africa. She has 27 years experience in several fields of law, notably tax laws, regulation in financial services, with developed skills in the broader commercial laws, corporate governance, and the constitutional and administrative laws of South Africa. Peter Nkuna is an experienced ombudsman with a demonstrated history of working in the insurance industry. He is skilled in insurance policy interpretation, compliance, investigation, claims dispute resolution, claims negotiation, claims handling, commercial insurance, claims recoveries, and liability claims settlement. Thokozile Mashlangu has 19 years experience within the short-term insurance market, with experience in claims management, underwriting, sales, marketing, and communications and drafting contracts. In today's session, we'll be looking at the principles of dispute resolution, its impact on the consumer, and what the insurer's role is. So just a little bit of housekeeping. In today's session, if you're going to be asked, if you have a question that comes up to your mind during the session, please leave it in the chat box. And then at the end, I will ask the speakers the question. At the end of the session, we'll also be taking questions on mic. To participate, please use the hand raising function available in the participant box. It's a little icon in your bar at the bottom that looks like a bunch of people. Just click on that, and then there's a little hand raising function in the middle. Then Thokozile will call your name, and then you can unmute your mic and ask a question. During the presentation, please keep your mic muted to keep interruptions to a minimum. Lastly, please follow the IISA, the FAIS Ombud, and the Ombudsman for Short-Term Insurance on social media, and please share insights from this presentation across your platforms. So I think we're almost ready to kick off. I just want to make sure that everyone who needs to be is in the presentation. Great. Thokozile, are you ready to kick off?
Yes, I am.
Great.
Ladies and gentlemen, good morning, and thank you for making the time to join us for this virtual training. It is a new normal, and we're most likely going to carry on like this into the future. It's something we've all had to adjust to, speaking to the screen and not necessarily touching and feeding the people, but we are all making progress in that. Just to add to the housekeeping rules, if we can ask that you keep your mobiles off or put them on silent, because when it does happen that it rings, it does interfere with the connection. And if you don't mind, you can keep your video off. Otherwise, it uses a lot of data and can interfere with your connectivity. But if that's not a problem from your side, please go ahead and do so. I see a lot of familiar, I was going to say faces, familiar names from the industry on here. We have a mix of people from the intermediaries side. Some of the people are from insurers. Some are just professionals in the industry. It's great. It's a nice mix of people. And we look forward to having the interaction. So this is going to be a very interactive session. I hope you've got all your questions ready for our experts. We are honored to have the acting FAIS Ombud in our presence, Advocate Nonku Shombe, and Peter Nkuna from the short-term Ombud. He's the Senior Assistant Ombud there. They all have they've got interesting information to share with us, and we're looking to you to really make the conversation interactive. As Tamara said, put your comments on the chat box or raise your hand in an electronic way as she guided us, and we'll rock like that. Dispute resolution is a term that refers to a number of processes that can be utilized to resolve a conflicted dispute or a claim without having to go to court. It's basically an alternative way of reaching a solution, amicable solution where there is a dispute. With that said, I'd like to hand over to Nonku. And if you can just put your video on, Nonku, for the 10-15 minutes overview that you will give to us on what your office does, and any other overview you're going to give to us, just 10 minutes, and then we'll move over to Peter, and then we'll start the conversation from there. Thank you.
Thank you, Thokozile, and good morning to everybody. Good morning to the listeners, and to the audience and everybody else in the session. As Thokozile has just outlined, dispute resolution is really a method of solving disputes, and it encompasses a couple of activities. The first one I would say would be the investigation. Once there is a dispute on the table, the dispute has got to be investigated to establish the facts of the matter. And it's got to be, the next step would have to be consideration. In this case, it involves, the consideration would involve the applicable law, and finally solving the problem or resolving the matter, either by dismissing it, right, or via an award that is usually contained in insofar as the FAIS audible. Hello? Hello? Hello?
Hi, Nonko. You were breaking up a bit, but I think you can continue.
Can you still hear me?
Yes.
Okay. Okay, you can hear me now.
Yes.
Okay. Basically, when it comes to the FAIS Ombud, the FAIS Ombud, first of all, is a statutory organ. A statutory organ can only do that which the statute empowers it to do. And I don't want to go into any length about that. I think we all know that. The FAIS Ombud is therefore provided by the Financial the Financial Advisory and Intermediary Services Act as a method, as an internal remedy for that should be available to complainants that have got complaints arising from the receipt of either financial services or financial products. Am I still audible so far? Hello? Hello?
Yes,
Yes,
yes, you are. You are.
Yes.
Oh, okay.
Hello?
I just have to keep checking whether I'm still audible, because you know these virtual methods of communication, they sometimes just disappoint you and drop you at an inopportune moment. So I'm going to keep asking if I'm still audible. Now, the common method of the FAIS Ombud in resolving complaints, it has somewhat leaned towards conciliation. When that fails, then we go into a dismissal of the complaint, and when that is not appropriate, then a determination will be prepared, and the determination is usually facing the respondent against whom the complaint has been leveled. At the risk of perhaps repeating something that everybody knows, I just would like to go past something that needs to be said, that I always feel that needs to be said with respect to dispute resolution. Whilst the method of dispute resolution and a lot of parties always prefer the method of litigation or judicial process, but the point is alternative dispute resolution methods have grown in popularity. And the reason for that is because a large number of society is not able to embark on the litigation process because of economical realities in South Africa. And that also accounts, obviously, for the fact that our statutes like the FAIS Act it was seen appropriate to have an internal dispute resolution mechanism that can be available to all and sundry, to everybody, whether the person has got the means or not. Still audible so far?
Yes.
Okay. Now to sketch.
Yeah, we can hear.
To sketch the process that is embarked on at the FAIS Ombud, we first of all are an institution that utilizes its services towards everybody in a fair and impartial and expeditious way, as much as we possibly can. And that is why it is so important for us, when we receive a complaint, we first must investigate it. And the investigation always involves engaging the respondent as well as the complainant to establish the facts, to establish all the facts, in order for us to have a proper picture as to what it is, what are the facts, what actually happened, what is the issue at hand. Now, I must just make a comment and say, we do want to put it to the industry properly and get the industry to understand that the process that is followed by the Ombud is inquisitorial, in the sense that we not, when we send letters of inquiry, we are not we're not in a space of blaming the respondent. We're not in the space of accusing the respondent of any level of lack of integrity or competency. We are at that stage investigating, and we're looking to understand exactly what happened and what is the first of all, what is the nature of the relationship, of the legal relationship between the respondent and the complainant. And also, having done so, then we establish whether we have jurisdiction. And having done so, then we establish what the facts are, what happened. And having done that, we then look at the applicable law. What is the applicable law in this particular instance? And if the matter falls squarely within the mandate of the FAIS Ombud, then that matter will obviously need to be considered with due regard to the FAIS Act and the FAIS Act, as well as the Code of Conduct for Financial Service Providers. Still audible so far, ne?
Yes.
Okay. Now this process, it does have its protraction. Its protraction is a function of the fact that we must, where it's not clear, it's not immediately clear what it is that we are faced with, we must make more further inquiries, and we must talk to the parties, because it would not be fair to understand only the one side of the story and not understand the story from the other side. And excuse me, in the current era, where we've got regulatory instruments, like, for instance, the treating customers fairly concept, and the treating customers fairly practice that has been introduced into the regulatory sphere, we do need to make sure that the outcomes of the treating customers fairly have been taken into account by the financial services provider. And if I can make a reference to a common document that we get from financial services providers, which is called a record of advice. My experience has been that particular document has not been particularly helpful. Because what it does is that it almost poses itself as more of a tick box that says, yes, here's a record of advice was signed and it is ticked, and the particular consumer got the advice that they were supposed to have gotten. But but the preferable way of doing this, which protects not only the consumer but also the financial services provider, is to actually state and go into content with regard to exactly what was done and what happened and how the advice, what the service provider, the financial service provider did to understand the client, to understand the needs of the client, and how the financial services provider matched the product or the service to the client with the needs of that particular client. And there's those of you that are familiar with the TCF outcomes, you will know all the various touch points that the TCF outcomes are looking for, because the idea is to be placed in a position where, as a financial services provider, you are able to assert positively that your client or the consumer was placed in a position to make an informed decision. And an informed decision obviously encapsulates that the client or the consumer understood the nature of the advice, understood the nature of the product. And in that process, it is also important for us as a FAIS Ombud to also establish that the financial services provider himself or herself understood the product that they were selling to, that they were marketing to the client, and understood the service that they were providing to the client, so that you know, we are now placed in a position where we are able to make certain assessments, we're able to find in a manner that is fair to both parties, in a manner that takes account of the atmosphere that prevailed between the two parties when the agreements in place were signed. And obviously, all of this is also dependent on the type of mandate that the financial services provider has from the client. And there are times, often, when a dispute arises, where the common cause that will be alleged by a consumer will be a lack of disclosure of terms and conditions that are applicable to the product and the limitations of the benefits that a particular product offers, which they would allege that they were unaware of those particular elements until the benefit claimed was denied or applied restrictively. The Code of Conduct for administrative and discretionary FSPs, as well as for authorized financial services providers and reps, in the prescriptions that it imposes, that they impose on these FSPs, it should be capable of resolving any allegation that is made by the complainant or the consumer that says that I was not told, when the consumer was in fact told. It should be capable. So what I would like to make clear by this is that it's important that as an industry we see a regulatory guidance like TCF. We see it as a guidance and as a method of not just working in favor of the consumer or the client, but also working in favor of the financial services provider. Because if the financial services provider is able to demonstrate that I put everything before the client and there's a clear record of all of this, as opposed to getting a record of advice that is just ticking a box saying that the client ticked the box and said, I understood everything. And the question is, did the client really understand everything? We must also not lose sight of the fact that a lot of clients, an overwhelming majority of clients that consult financial services providers, they rely on them to give them they operate under the belief that that financial services provider understands what I'm looking for, understands my circumstances, has advised me, has put me in a scheme, a product, or given me a service that will be good for me going forward. And they shall I say, there is an element of trust and an element of respect by an overwhelming number of consumers and clients with respect to the financial services providers that they consult. Am I still audible?
Yes, you are.
Okay. Now, if I'm dealing with an audience that understands and knows all these things, I must apologize, but let me, just for purposes of being all-encompassing, let me just now kind of trace what happens when we receive a complaint at the FAIS Ombud. The FAIS Ombud, as we all know, the FAIS Ombud is centrally located, and it's in Pretoria. It's in Tshwane, and received the majority of his complaints via email, Complaints are also received via the posts, via fax, via incoming calls, via visits to our client care center, and walk-in complainants, except for now, ever since COVID restricted movement, we no longer have walk-in complainants at all. The client care center plays the role of being a first point of contact at the FAIS Ombud. And it evaluates all complaints received and determines which matters fall within the mandate of the FAIS Ombud. Having done that, those complaints that fall within the mandate of the FAIS Ombud, the client care center will then contact the complainant and advise the complainant that the matter has been received and will be remitted or referred to the correct forum. The referral of complaints to the correct forum may be whether it's another alternative dispute resolution office or to the financial services provider, because the financial services providers have also they also have their own offices, complaint offices, where you might find that this particular client can be assisted by this particular financial services provider. Now, all the complaints that fall within the FAIS Ombud's mandate, then they receive the acknowledgement letter that confirms to the complainant, and then they get transferred to the case management department for further investigation. This is now where you remember that earlier on I mentioned the fact that we write letters of inquiry to the respondents and to try and establish what is the story from their side, because we need that information. And all those complaints that fall within our mandate and within our jurisdiction, we then begin the investigation process. Once that happens, a case manager gets allocated to a complaint in keeping with the FAIS Ombud's commitment to customer service. And we always endeavor to do so within 7 days of the receipt of a complaint. And then an in-depth assessment of the complaint is made by case management. And this is now encapsulated in all the inquiry letters that I have referred to. In the event that the complaint does not have substance, we believe that the complaint does not have substance, then the complaint is dismissed, and the reasons for doing so are provided. However, where the case manager is of the view that there is a merit to the complaint which warrants further investigation, then again again, the respondent will be contacted, and this will take the form of how the rules are guiding us. I hope my audience knows all about the rules that were set up by the then board of the Financial Services Board that we follow with respect to dealing with complaints. When once we are done with that whole procedure that is contained in the rules, depending on a particular matter, I mean, it's not like we apply all the rules in all the matters. It will depend on a particular matter. Once we have got a clear picture of what is going on, then what we do is then we begin to consider the matter with reference to the law. And the law, the legal matrix that I've referred to, being the FAIS Act, being the Code of Conduct, and being the rules, and being the FAIS Act. Also nowadays, as I say, we also have TCF. We also have the Financial Sector Regulation Act. That's the Financial Sector Regulation Act. That's the statute that introduced Twin Peaks within the financial services industry. Once all the documents have been collected, we then begin to look at whether we are in a position to issue a determination having applied the law in terms of the facts, and in terms of what has come out of the investigation and what we have established. The FAIS Ombud, in terms of the FAIS Act, has got the powers to hold, shall I say, inquisitorial sittings where the complainant and the respondent can attend to what I would call almost evidentiary sittings. But that is done when the FAIS Ombud believes that there is evidence, or there is material, or there is information that we are not getting, that we do not have. Then we hold that kind of an inquiry. But the FAIS Ombud, it must be noted that during the investigation, at that stage, the FAIS Ombud, it explores every opportunity to informally resolve the complaint in the interest of the parties. And sometimes this involves the facilitation of a conciliated settlement, or meeting with the parties to negotiate a positive or a resolution, which obviously takes account of the matter and the facts and how everything unfolded. Then that constitutes a consideration of the matter, that the parties can walk away feeling, all right, either there was a mistake, or I didn't understand, or etc. etc. But this whole process, we try to make it as informative as possible. But I must say that,
can I come in and ask you to maybe just hold it there for the sake of time, so we can have the desired engagements that we would like.
Sure.
Peter, can I ask you to come in and just give us an overview, 10 minutes, and then we'll open to the delegates for questions. I can see there's a couple of questions that have been put on the chat, but we'll go into those after your overview, Peter. Thank you.
Thank you very much. I'll try and keep it very short so that we can get to the stage where we are more interactive than we have been thus far. What also helps me is that a lot of the business that our office conducts is pretty much the same as what the FAIS Ombud's office would do. So in a way, it helps that I will not have to go into as much detail. Let me start off by asking the question, who or what is OSTI and what does OSTI do? We are a voluntary ombudsman scheme or dispute resolution forum established by the short-term insurance industry to resolve disputes between insurers and their own clients. And this was designed as a self-regulatory mechanism through which confidence in the industry could be maintained, in the sense that consumer get to know that should we not be happy with the service and the products that we get from our insurance providers, there is somewhere we can go to, somebody to whom we can go lay complaints, and that being an independent objective arbiter who can then look into the dispute and resolve it impartially. And this was essentially a mechanism through which also there was a desire to grant more access to justice, because over the years it has become quite difficult for the ordinary man in the street to access justice. And there's a general saying that it is easier for people, the poorest and the richest, to access justice, and then the majority of us that are in the middle, it's difficult. And the reason why the poorest can access it a little bit better than those that are in the middle is that there is a legal aid assistance that is available to them, and obviously for the rich people, they can afford to carry their own costs. Our office is recognized, is a scheme that is recognized in terms of the FISOS or FSOS Act, the Financial Services Ombudsman Schemes Act, and therefore it is operating legally. And it is basically our functions and our powers are derived from the Act, from the Memorandum of Incorporation and our terms of reference. And the kind of complaints that we deal with are basically your claims and policy complaints in general. If complaints are more service related, most of the time we are unable to assist purely because our jurisdiction is such that we can only provide a remedy of sorts if there's been a financial loss suffered by the complainant or the insured. And obviously in a lot of pure service complaints, you would find that there may not be any financial losses suffered by the complainants and the insureds, and that's why we wouldn't be in a position to provide any relief for them. We deal with domestic personal policies, by that car, home, all risk, travel. I think people are probably aware of all of that detail, so I'll just leave it at that. Business insurance as well, and perhaps there I should just distinguish it from commercial insurance, with regards to which we have a limited jurisdiction. And perhaps as we discuss later on, that might be addressed a little bit more in detail. How do we resolve complaints or disputes? Pretty much the same way that the FAIS Ombud's office does. It's an investigation. We do most of it through correspondence and the exchange of documents and evidence. And recordings, if that happens. Sometimes even video footage becomes part of the evidence package that we receive from the parties during the investigations. And once we have got all the information that enables us to make a decision on a matter, a decision would then be taken. And that is basically through the application of law and legal principles. And in exceptional cases, we would then look at considerations of fairness and equity. The kind of instruments that we use in terms of making our decisions, like I said, will be using law, but we also have PPR, although PPR these days is also part of the law, so maybe I shouldn't make it as a special type. We also look into the SIA Code of Conduct, TCF principles, which are also now part of the law, so perhaps we shouldn't distinguish them anymore. What do we do in that process of evaluating disputes? We rely a lot on principles of natural justice, and by that I mean we use principles like the audi alteram partem principle, meaning that you listen to both parties, allow them to make their presentations of facts and evidence, and then we will also conduct ourselves and the investigation in an objective manner, being independent of influence from any of the parties or even outsiders. We operate without fear or favor, as they say, and we exercise a lot of discretion in conducting our function. Quickly touching on our jurisdiction, we have got, in terms of the values, we can deal with claims up to the value of 3.5 million on all the claims except for building claims, with regard to which our jurisdiction is 6.5 million. Like I said earlier on, we have a limited jurisdiction on commercial policies, which are to be distinguished from business policies, which we should be able to assist with. We have no jurisdiction on marine policies, and the essence of why we would not be dealing with some of these policies and having only a limited jurisdiction on some of them is that the resolution of the disputes relating to these may be quite complex, and the dispute resolution mechanism envisaged when OSTI was established was that it would be those matters that are fairly easy to resolve without too much required in terms of resources, where it is fairly easy for a party to collect all the information and evidence, weigh it up, and make a decision as to what should happen from there. And that is why we would not be dealing with marine and commercial policies to a certain extent, because they do tend to be complex. How do we resolve our disputes? The outcomes will generally be, firstly, if it is found that the complaint is without substance, and that can come in the form of the facts are clearly nonsensical, those would be the facts alleged by the complainant, or there is no sufficient evidence in support of the complainant or the insured's version or complaint. In that case, their case would be dismissed, or the dispute or rather complaint would be dismissed. There can also be a finding in favor of the complainant if it is clear that the insurer applied the policy terms and conditions incorrectly, or perhaps even unfairly. There are instances as well where we find that based on the available information and evidence, it is not possible to make a decision either way. And in those instances, we will declare a dispute of fact. And a lot of times we will also in that instance refer matters to alternative forums like courts and any other that may be applicable. Perhaps before I stop, I want to quickly just touch on something that a lot of people might have heard of, which is that OSTI, which is the short-term insurance ombudsman, and OLTI, which is the long-term insurance ombudsman, have amalgamated. Just to clarify, because this comes up quite often in our discussions. The amalgamation was a soft one, and it has been since I think it was the beginning of this year. And we basically by that mean that although both offices still operate separately and independently of each other, a complainant may approach either of the offices with a complaint, and the office that receives that complaint can then determine whether it is its own complaint over which it has jurisdiction and then process it accordingly. And alternatively, if it is found that that complaint relates to a matter that belongs to the other office, it will then be seamlessly transferred to that other office without the complainant having to experience that they went to the wrong office, if one can put it that way. So there is one entry point, a shared portal, and we do a seamless transfer of calls and documents between the offices. And we also currently share the head of the adjudicative function, and this is in the person of the retired judge, Ron McLaren, who is heading both institutions. And I think I'll stop there, and then perhaps we can start doing the interactive part of the session. If there are any questions, we will deal with them in that regard. Thank you.
Thank you, Peter. That was a lot of information that is relevant, and thank you, Nonku, as well. There are a few questions on the chat. We won't be able to get through all of them, but I'm gonna just, some are not entirely clear. I'll probably just ask the person to come on and clarify. The first question from Safaraz Rasul, I hope I pronounced your first name right. How are we short-term insurance brokers expected to disclose all material facts? That's the question. Anyone can take it between Nonku and Peter. I think I'm going to assume, and Rasul, just come in if I'm going to paraphrase your question correctly. What Nonku mentioned is that the record of advice that they receive seems to be more of a tick box exercise and not necessarily giving comfort that the content and detail of the advice was understood by the client. I think that question is sort of a follow through from that. How do you, as an FSP, give yourself comfort that the client understands what you've advised them on? Rasul, am I understanding your question correctly?
Yeah, the question is very simple. I don't know if everybody can hear me.
Yes, we can.
All right, so the challenge, what we're finding at the moment is there's one set of regulation that's regulating the short-term broker as well as the long-term insurance broker in our country. And at some point, I hope that National Treasury, together with the FSCA and the relevant role players, start to create the demarcation. But I'll give you a simple example. We are specialists. We like to consider ourselves as being specialist commercial engineering and commercial brokers, right? So if we're selling you an insurance policy for your engineering business or your manufacturing business or your construction business, and we've explained as much as we can the extensions, let's say, for example, under business interruption, you get prevention of access, public utilities extended cover, you get selected suppliers. There's so many extensions there that certain businesses require and others don't. Now, the point I want to obtain clarity, and seeing as we got the FAIS Ombud as well as the assistant short-term Ombud in this forum, and we thank both the individuals for coming over. Where do we draw the line? Where do these officers draw the line in terms of where our responsibility ends in terms of disclosing material facts? Because a policy contract of this nature, especially a multi-Mark III policy, which is quite a detailed lateral binding contract between the insurer and the insured, we can't go through every material, whether it's now is it 60% material? It may be 50% material to one client and 80% material to another client. I don't know. We can't go through that entire document with a client in even a day. It would take a good few days to run through it. Some of us brokers are trying to create text, clip art and audio visuals to make it easier for the client to understand. But the question is simple. Where does our responsibility end with regards to disclosure of material facts? Because there's a lot of facts that are material in my opinion. And the only way I see it is the fact that we send that document to the client and we reiterate to the client constantly, please go through this and come back to us if you do not understand, which, by the way, 99% of clients don't read. So that's my concern.
All right. Thank you, Sarafas. Do you want to come in, Peter?
Yes, I'll take that one, and then maybe Nonku can take over where I may have not addressed things. Now, I think our approach is fairly simple, and I think Safra's question is a bit awkward in that our office doesn't deal so much with the types of policies that his organization seems to be dealing more with, because those are complex ones. And like I explained in my earlier introduction, we tend to deal with the simpler disputes because there is a recognition of the complexity involved in the types of policies that they deal with. But in general, this is the approach that we would take. In terms of the policyholder protection rules, it is stated clearly that the essence of the type of cover that is provided in the policy must be discussed with the insured, so that there is a common understanding of that which it is that is being discussed and purchased. So in other words, ultimately, one needs to be sure that in the discussions that took place at the stage when the policy was being sold, the consumer understood the product that they were buying. They understood the benefits that it provides. They understand the limitations that are there. They understood the responsibilities that come with the benefit of enjoying the cover. And if one has covered that fairly reasonably, comprehensively, I think you stand a better chance of being seen to have been compliant substantively, and not just as a tick box like it was stated by my colleague earlier on, which sometimes proves to be the case. And I think Safas also indicated that from what he said to me, I would venture an opinion that that is probably not compliant. Simply sending a policy out to the insured and saying, go read it, and then if you don't understand it, come back. I don't think that is sufficiently reasonably compliant. One has to at least go through the essential bits of the policy to get the insured to understand the essence of the product before they can be seen to be compliant. And there have been instances where a particular point would be found to have not been canvassed, or in fact, let me put it this way, the complainant will say, this specific issue was never discussed with me. But when you look at it, it's something that is a fairly generic policy provision, and it's not a very complex one. And it is also clear that the bit around that specific aspect was discussed in general terms, to the extent that it can be argued that the broker or the financial advisor complied in that regard, and perhaps what needed to then happen further, and perhaps even the documents may have said so, go read a little bit further. Having had the basic discussion, there's also still a responsibility of the consumer to go do a little bit more work, and then if need be, have further discussions. So that is roughly how our office would approach it. And I will leave it at that. Thank you.
Thank you, Peter. Madam Chombe, I don't know if you'd like to add on there. Nonku? I think she's still muted.
I'm
oh,
here.
There she comes on. Yeah. Would you
here.
like to add on to the response provided by Peter?
Yes, just one. But Peter covered it all really. I just want to sort of help the gentleman. Sorry, I didn't get the name. The one thing that I think is important is to, when you are placed in a position where you must provide financial advice or provide a financial product, the one thing that is very important is to understand the client and the client's needs. Because if you are able to, in your records, you are able to show, here is my summary of what the client was looking for, what kind of client it is, and what they are looking, what the concerns are. And is it a new client? Is it a big client? Is it a medium size? What are the risks? Touch points that show that you, as the financial services provider, you first understood the client. And as you provide it, and then follows what Peter says, you then begin to see what the client needs. What is it that the client needs? What are their concerns? What do I need to worry? What do I need to address in the products that I provide? And then once you have done that, it show, and you have had that discussion with the client where you then say, I believe your outfit is this kind of outfit. The risks are the following. These are the concerns that you have. It then becomes clear that as you are dealing with a client, you were putting yourself in a position where the client sees that you know what you are with them. You are giving them a sandwich. You understand? Because they need a sandwich. You are not giving them lobster because they don't need lobster. I don't know if that helps. I hope it does, because I think that also from the FSCA perspective, the FSCA would, by the way, I used to work at the FSCA, the legal department. So the FSCA would also be very willing to assist for purposes of certain areas of the industries where it is not particularly clear how to apply the treating customers fairly concept and all the new regulatory aspects that seek to regularize the industry.
All right, thank you, Nonku. There is a long question from Yolanda. Can I rather ask Yolanda that you come on and rather put your question so we can all hear instead of me reading what you wrote on the chat? Can you come on?
Yes, sure. Can you hear me?
Yes.
Okay, sorry, I do have bad connection, so just let me know. So my question is, the policyholder is a commercial or corporate client. So in terms of PPR, their turnover exceeds 2 million rand annual turnover. If we get a third-party claim, what we do is, do we deal direct with the third party to tell the third party that the liability policy is not responding? Or do we deal with the insured, send the repudiation letter to the insured with the reason and just inform the third party that the policy is not responding and that they can go to the insured? The reason why I'm asking is, if we do deal direct with the third party will then come to you with complaints if they feel that the policy should have responded. Is the question clear?
I think I understand it.
Yes.
And I can venture an answer if that's all right.
Sure.
I think as a starting point, maybe I should mention that our office doesn't get involved doesn't have the jurisdiction, as a matter of fact, in liability claims. but I happen to have dealt with liability claims, and I am of the view that general good practice would be you have to deal with both of them. Firstly, because your main relationship is with your own client, and I think it's just commonsensical that you would want them to be abreast of what is happening with their policy and claims against them. Secondly, because this is a liability claim, and you are basically standing in the shoes of the insured. If you were not to liaise directly with the claimant, what would then happen is that the insured, despite having cover, finds themselves having to deal with this claimant, and sometimes it might be awkward and even unpleasant having to have that kind of experience. And therefore, as the insurer, it would be probably better if the insurer stood instead and dealt with the claimant directly. And in doing that as well, what happens is that the insurer will be aware of developments and be more responsive. For example, if there is no settlement forthcoming because the insurer is not willing to settle, and the third party then threatens legal action, the insurer will immediately be aware that the complainant or the claimant rather is going to approach the courts, and then can be responsive in that regard, and perhaps can even invite the claimant to say, when the summons is issued, you can serve it directly on our lawyers, so that our client doesn't have to bear with all of that unnecessary emotional involvement that may have to take place if they were that directly involved. So in my view, the short answer would be it would be ideal to deal with them both, because they have different interests in the matter. And if you're servicing your client, you need to speak to them from that perspective. And likewise, if you're responding to a claim, you need to do that properly, and that can only be done if you are liaising directly with the claimant as well. Thank you.
Okay, I'd like to give you a practical example of what actually happened, and the OSTI has thrown it out. The policyholder is the municipality, and the third-party claimant claimed that the municipality was negligent and water damage caused damage to the property, and she wanted a house rebuilt. However, the insured wasn't negligent, so the liability policy wasn't triggered. So it wasn't a valid claim in terms of a policy. The third party then went to the OSTI to put a complaint in against us, an insurer, because the policy doesn't respond to it. So how would you deal with that?
Well, in the first place, a third party does not have the right to approach OSTI to complain, because our terms of reference are quite clear in that, and I think I mentioned that in my intro as well. The office exists to resolve disputes between insurance companies and their own clients. So as a third party complaining against somebody else's insurer, that automatically takes you out of, you don't have what is called locus standi. You don't have the right to go to OSTI for relief in that context. Secondly, I also indicated that we do not have the jurisdiction to deal with liability claims, and that would also be a second ground on which the complaint by the third party claimant would have been dismissed, and they can then go to court, and perhaps they can then start dealing with the merits. We can't even deal with the merits just because of those two technical issues as a starting point.
Okay, so even though the third party is seen as a claimant in terms of PPR, they can't come to the OSTI if they, okay.
our current terms of reference are that you can only approach OSTI if you are claiming against your own policy from your own insurer. Anything
So
outside of that, not currently. It's possible because our legal framework is changing so much, and I think government is recognizing that. We need to be opening things up to allow more and more people to access justice. It is possible that in the future somebody, maybe even if not necessarily our office, but there will be somebody that has to look into disputes of that nature.
So that third party, which obviously is somebody who doesn't have a lot of means, would either have to go direct to the insured or do litigation currently, as it stands now.
Well,
I'm just checking.
Yeah, the answer that we would normally give in that regard is that, look, what you do is your own business, go seek legal advice and then act accordingly. All we can tell you is that our office is not in a position to assist you any further, and the best way is seek legal advice and then act accordingly.
Okay,
Yes.
great. Thank you very much.
All right. Thank you, Peter. There is more of a statement from Buisiwe Hlatshwayo. From a regulatory body perspective, she writes, would it be correct to say that the time has come to review the standard policy wording templates / multi-mark to address the regulatory requirements, or is it about the awareness to the insured? Buisiwe, do you want to elaborate what your question is there exactly?
Sorry, apologies, just needed to unmute. No, I think, yes, I wanted to sort of get the context of, from all the complaints and even from a FAIS perspective, is it about the wording that the insured, that the interpretation that's causing these disputes, or is it more about that the insured is not necessarily aware? And from an insurer perspective, what is the approach that we really need to take? Because there is that first element where the broker and the advice element is crucial. And at a claims perspective, it's about applying what the meeting of the minds would have been at the time of that engagement. And we find that when the interpretation of the wording is looked at, we're not clear whether is it time that we start assessing the wordings in terms of how the regulator wants us to sort of make them more simply or simplified for the insured, or is it just about saying, let's have the insured being made clear of what they are getting from the beginning? And I think that's just from an interest perspective of what their view is with the experience.
Okay, let me take a first stab on that, and maybe Peter might add. If I must again take the matter back to the TCF outcomes, right? The TCF outcomes, they look at the principle of culture and governance. That's the first thing. And that's not what we're talking about here. Culture and governance is about culture and governance at the insurer as an entity. Then the second principle is product suitability. That's an outcome that is expected. The third principle is disclosure. And that disclosure really means that the consumer must know everything about the product. The consumer must know what the product provides, what is the risk that the insurer is taking, what is the actual risk, if it's an insurance. If it's not an insurance, if it's something else, then disclosure means that the consumer must understand exactly what are they buying, What are they, if they're purchasing, like for instance, it's a purchase of shares, what is the status of the company in which they are purchasing these shares? And in an instance where the consumer is expecting to get a monthly income or monthly investment income, there needs to be a clear indication of where the income will come from. What is the underlying asset that is going to be producing the income that is relied upon to produce the income? And I know sometimes these are not linear things. These issues, they don't exist in a linear fashion, but there needs to be a clear indication to the consumer. What exactly, what is it that I'm buying? Where should I be looking to see how my investment is performing, if I can do that? And then the next principle is suitable advice. Suitable advice touches on what I was saying earlier, the knowledge and the understanding of the client, who the client is, what the client does, how long the client has been in business, what the client's concerns are, what is it that I, as the insurer, should be thinking about as I think through the process of providing them with a particular product. And then the performance and service in line with expectations. In performance and service in line with expectations, again, it touches on the question that says, if I was promised that if A happens, this is what we will do, then that should be clear in the documentation at the time of the agreement of the conclusion of the agreement, that what it is that I expect in line with expectations. If the cover says, if I break a leg, if I break my leg, this is what my product advisor will help me with. And also the claims, complaints, and changes. The claims, complaints, and changes, all of those principles, they seek to in a way encapsulate some kind of guidance to ensure that the insurer is able to provide a suitable product, so to speak, a product that the consumer will understand, and the product that the consumer will be able to deal with going forward. And again, if you look at the policyholder protection rules, the policyholder protection rules are very helpful in the sense that they start to warn you as the insurer as to what are the protections, what is it that the client can come along and complain about with respect to what you have done, to the agreement and to the subsequent service that they've received, because they make it very clear what it is that must be ensured, that what the protections are that the policyholder can expect from the insurer.
Nonku, can I come in there?
Yes.
We've run over time, 13 minutes over time. If the delegates are comfortable that we take 2 more questions, happy? It is clear that we perhaps need to have another session on this matter in the near future. I see Andre's mic is unmuted. Andre, do you have a question? Andre? Okay, I don't seem to be getting a response from Andre. Can I just put one last question to both of you, which I think is for the benefit of all of us. Are there any anticipated changes in legislation that could affect the operations of both the FAIS Ombud and OSTI, including short-term and long-term, that we should be aware of as FSPs and as consumers? Anything that you'd like to share with us that we should look out for?
Again, Peter will assist me if I leave anything out. Currently, I'm sure everyone will possibly be aware that there is a coffee legislation that coffee bill, actually still a bill that is still under discussion. And that legislation is a legislation that is going to replace, or at least my understanding, you know how these things will change and change direction and perhaps change emphasis. But that legislation is a legislation that is expected to pull all the various sectoral pieces of legislation together and have one piece of legislation that will be comprehensive. Whether that legislation, the coffee legislation, by the way, it will be the conduct of financial institutions legislation, which again already tells us that it's a legislation that will deal more with conduct. So with the regulation of market conduct. So the insurance pieces of legislation, for instance, like the Insurance Act, to the extent that the legislation is looking at more the prudential aspects of the legislation. I mean, of the industry. That I expect may very well be in a different legislation, which would be the Insurance Act, which is regulated by the Prudential Authority. That is one piece of legislation. The expectation is that a lot of the legislative framework has already been put out into the industry. How has it been put out into the industry? Exactly the documents that we've been discussing, the policy protection, the policyholder protection rules, sorry, the TCF, and all the other pieces of legislation that exist in the code of conduct. So the actual framework is out there already, but obviously, because we are now in a world of two peaks, and we're not in a world, in a sectoral world like we used to be, there has to be a single piece of legislation that deals with the regulation of the conduct of financial institutions. That's the one thing. The second piece of legislation that still is coming on stream in incremental stages is the Financial Sector Regulation Act. Now, there is a chapter in the Financial Sector Regulation Act, Chapter 14, which deals with the establishment of the Ombud Council. Now, the Ombud Council is expected to be a council that will be an umbrella body that will contain all the various ombuds, the statutory ombuds as well as the voluntary ombuds. The voluntary ombuds will obviously apply for recognition by the Ombud Council, and they will resort under the Ombud Council as recognized by the Ombud Council. The statutory ombuds will operate in the way that they've always operated, and with reference to the statute, and the statutes at that time or in future, or however the plans pan out at that time, the various statutes may already have been consolidated into the conduct of financial institutions.
Sorry, can I interrupt for the sake of time. We're almost like 20 minutes outside the scheduled time. I'm worried that delegates may have other commitments that they need to get to, and that will impact us negatively. I would like to suggest that perhaps we have another session in the near future. The office will be in touch with yourselves again, maybe to have another session, if that's okay with you as well, Peter. And maybe we just have a Q&A then, today, having laid the foundation almost. Or is there something you'd like to add, just maybe 1 minute, Peter?
No, I think she was quite comprehensive in covering issues relating to the upcoming legislation or legislative changes. And yeah, I think both offices are probably more than willing to have additional sessions where we can have further interactions. Thank you.
Thank you very much. We appreciate your availability, and we really look forward to having another session and maybe more of a Q&A only. In closing, we have learned today that it's very important to understand the client needs and understand the actual client. It's very important that we communicate the benefits, the risks, and the limitations of the products that we make available to the clients. It's also important to note that the short-term ombud and the long-term ombud have amalgamated into one, and that's a big change that perhaps some of us were not aware of, and maybe in the near future it will be unpacked on how we are impacted as FSPs, and Peter did highlight how the consumers are impacted, no change basically. It was also important to learn that there are limitations in jurisdiction on the OSTI side. I hope we're still allowed to call you OSTI. I don't know if you're going to be doing a name change.
I think ultimately that's envisaged to be something that will definitely have to happen. In fact, I think in the social media we have already started using the insurance ombudsman for Twitter, for example. I know that's what we are using for our Facebook page. That's what we are using. I suspect soon the rest of them will also be changed to be that.
Okay, thank you, and thank you very much to everybody that managed to stay up tonight. I did see some people saying goodbye. You've been a great audience. Thank you for the interactions. We'll have another session on dispute resolution and more of a Q&A, so we can just address all the questions that our guests and delegates, members and non-members, basically the industry has. And what I would like to also highlight is that stay connected with us, keep in touch on our social media platforms, look out for our newsletters. We share quite a lot. Our website has got a schedule of all upcoming sessions that will add value in your world, enhance your knowledge, and also the sessions are CPD accredited, so you will be getting CPD hours as well. And once more, thank you, Peter, and thank you, Nonku, for your time. And to all delegates, thank you very much. We appreciate your availability, although we've gone over. Thank you for your understanding. Thank you.